Madam President.
Senator from Georgia.
First of all, I thank my colleague from Georgia for allowing me to come over and speak on this, and I rise to concur with the resolution introduced by my friend and my colleague, Senator Isaacson. For more than 75 years, our labor laws governing airline and railway employees have been upheld under both Democratic and Republican administrations and in 2 Supreme Court decisions. Recently, however, the National Mediation Board acted unilaterally to change a long-standing statute without seeking the consent of Congress. Unfortunately, this change is based more on politics than on the merits of the law. Historically, if you had 100 employees who wanted to vote to form a union, you would need a majority of those employees or 51 to vote in favor of unionizing. Now, in accordance with the new rule change from the Mediation Board, if 10 members choose to vote on whether to organize, a majority of 6 members voting yes would bring all 100 members under union control. That's not the way the law was ever intended to operate, and it should not be changed by an arbitrary action on the part of this board. Not only would a minority of voters have a tremendous influence, or a minority of workers have a tremendous influence over other employees in such a workplace, but when a union is formed, employees would not have the same right to decertify the union under the new minority rule. While the Obama administration is attempting to amend our labor laws in order to facilitate the unionization process, the old majority rule was anything but anti-union, because today an average of 72% of railway and airline employees are unionized, compared to only 8% of all workers in the remainder of the private sector. Not only is the new rule change flawed, but the procedure by which it came about was dreadfully biased. The National Mediation Board is made up of 3 members and has existed since 1934 to coordinate labor management relations within the railroad and airlines industry. The 2 Democratic appointees decided to move forward with this rule change without input or participation from the Republican-appointed chairman. What the National Mediation Board has implemented goes beyond the scope of its capacity as well as its jurisdiction, and it's going to result in a rather lengthy court battle if this rule does come about. There is no need for this rule change when 78% of the airline and railroad industry, 72%, is already unionized and have had the opportunity to unionize under this law. The responsibility of a change in labor laws of this magnitude and affecting this many workers should ultimately rest with Congress, not with a small board of political appointees. I'm proud to be an original co-sponsor of my colleague from Georgia's resolution. I urge my colleagues to follow his lead on this issue and to pass this resolution. And Madam President, I would yield back the balance of my time to Senator Isaacson.
Madam President, I note the absence of a quorum.
Clerk will call the roll. Mr. Urcaga.